because we did get breaking news that the TRO has been granted in this case. So now we know moving forward that this TRO is going to be granted and it will stay in place, the preliminary injunction. Yeah. Correct.
So with this preliminary injunction now being granted, what do you think this means going forward in terms of immigration enforcement here in Chicagoland?
Well, it's really hard for me to answer that without reading it. Obviously I'm on live with you. I don't know exactly what it says. My best guess would be that it says comparable things to what the TRO said, at least some of the same restrictions on conduct, like, giving verbal warnings, et cetera. But I think what really matters, or a big part of what matters, is whether or not the federal agents actually comply with it, which there's plenty of evidence that they haven't been doing. And again, we'll have to see then what are the different pressure points to respond to that. If they don't abide by it, and there's going to be things that are going to have to play out. If that happens, of course, nothing that Judge Ellis has been asked to do calls off immigration enforcement in the Chicago area or anywhere else. It doesn't prevent federal agents from engaging in immigration enforcement and doing so pretty aggressively. What it prevents them from doing, or should prevent them from doing, is violating people's rights in that process. For the, there's no, Judge Ellis is not going to tell the federal government that they have to pull their agents out of the area and just stop engaging in this effort. She's not going to say that.
Okay, thank you so much, Carolyn Shapiro with Chicago Kent College of Law. Maybe just on a final note here, because we do keep going back and forth between this preliminary injunction versus TRO statement. Give us the difference between the two, the technical difference between the two.
A TRO can be granted very early in the case with a relatively small amount of, relatively speaking, less process, less opportunity for both sides to present evidence. Certainly the plaintiffs have to present some evidence, but the idea is that it just freezes the status quo, or stops people, or in this case the government, from engaging in illegal activity while the judge takes more time to learn the case better, while the lawyers develop their record, their evidence, and bring it back in front of the judge. By rule, the TRO can only last 14 days at a time. It can be extended once, but it can't be extended after that. At that point, it's something called a preliminary injunction, which is issued on this more robust evidentiary record. And another important difference is that it can be appealed. A TRO, generally speaking, can't be appealed. There are exceptions to that, but that's a general rule. But a preliminary injunction absolutely can be appealed, and I would expect that the government will do that.
Thank you so much. We appreciate it, and we appreciate everyone staying with us here for this extended coverage here, our special report. Again, the breaking news that we've just found out, the preliminary injunction has been granted in this case with the Headline Club, and so protesters, journalists who have now won their case against the federal government, and specifically Gregory Bavino, the commander of Operation Midway Blitz.